Everybody, my name is Paul Jones. I am the Director of Project Rebound located at Cal State University, San Bernardino. I would like to thank you all for coming out. Before we get started, I would like to thank a few people. One, I would like to thank all our community partners that helped put this event together. I would like to thank the presenters who took the time out of their day to share with us their expertise. I would like to thank Dr. Tilton for her ever support and vision of what we're doing at the IE Fair Chance Coalition. I would like to thank my interns who have been an integral part of this, Rosa Maria Lopez, Roberta Fox, and Martin Johnson, as well as the Cal State San Bernardino partners. And with this, I pass it over to Katie.
Good morning, everyone. My name is KD. I am the Fair Chance Community Organizer with Legal Aid at Work. I'll introduce myself a little bit more later. Right now, I would like to take this moment to ground today's presentation in the reality of the current uprisings and the current movement that we see taking place across our country. 50 years ago, Black Americans descended upon Washington in the famous March for Jobs and Freedom. And today in 2020, we are still marching for jobs and freedom. I am proud to be doing this work, and I am proud to be carrying this torch. As a member of All of Us or None, as a formerly incarcerated person, as a Black woman, as a Black American, I stand in solidarity with the peaceful protesters. I stand in solidarity with those that have taken a more direct approach. And I stand in solidarity with the revolution as it continues to evolve and bear fruit. The Banner Box movement began as a direct response to the civil and human rights that have been stripped away for far too long, for far too many. All of Us or None stands ready to continue to challenge the pervasive discrimination that currently and formerly incarcerated people face here in this country. The Banner Box movement has always been and will continue to be a call to action, a direct opportunity to challenge and dismantle institutional policies that continue to plague the Black community. Today, the Banner Box movement now spans the country, and fair chance policies are on the forefront of today's civil rights movement. Mass incarceration and police brutality, this is the civil rights issue of my generation. I am more than humbled to be in community with you all today. And I am grateful, excited, and proud to be participating in the fight to restore civil and human rights for formerly incarcerated people. And the Banner Box movement is a movement that I personally believe in. Thank you so much.
And now we'll have Stacy Villalobos to come and speak and give our main presentation from Legal Aid at Work.
So we'll be talking today about employment after incarceration. And we're going to start off with introducing ourselves. All three of us will be giving the presentation. My name is Stacy Villalobos, and I'm a staff attorney at Legal Aid at Work, where I work on issues of racial economic justice. And I'm very excited to be here, at least virtually, with you all, both because I grew up in the Inland Empire, and my cell phone number is actually still a 909 number, but also because this issue is very personal to me. My uncle was actually just released from federal prison last week. So the issue of employment after incarceration is something that is really personal to me.
Thank you again. My name is KD. I am, again, the Fair Chance Community Organizer with Legal Aid at Work. I am a proud member of All of Us or None, who I believe are stewards of the Banner Box movement. And I'm formerly incarcerated. My entire family is formerly incarcerated. And I am, again, humble, excited, and proud to be on staff with Legal Aid at Work and to be doing this work. Thank you.
My name is Molly Lau, and I'm a summer law clerk at Legal Aid at Work. And this issue is also personal to me. I just had a cousin recently be released from state prison. And so these issues are very important to me. So Legal Aid at Work, we here at the Civil and Workers' Rights Organization help others through clinic and helplines, and we offer free services to about 3,000 people across California each year. Some of our free services include extensive practical legal services through employment trainings and helplines. We advocate for policies as well on the local, state, and national level. And we also enforce employment rights by litigating in federal and state courts. So we have workers' rights clinics all throughout California. And I just wanted to highlight the San Bernardino clinic, the number with the 909 number that you can see here on this slide. And basically, the best number you can reach legal aid at work and workers' rights clinics is at the bottom of the screen, the 415 number, if you were to need any help with workers' rights issues. So a little bit about our agenda today. Just wanted to touch on and the overview of the California's Fair Chance Act. Stacy and I will be providing that brief overview. And there are three main parts of this law. And if you were to remember anything from today's training, remembering that there are these three major parts of the law, I think that this training will have been successful. And so the first part is regarding off-limits information. The second is about the ban the box portion of the law. And then the third part is basically navigating the fair chance process. And so throughout this presentation, we'll give you an overview of how you can navigate the fair chance process, and also about other workers' rights laws and resources that are available out here.
We wanted to start our conversation about Ban the Box, or the California Fair Chance Act, by noting that, you know, this law is a product of organizing and years of work by all of us or none, which, as Katie mentioned, it's a grassroots organization made up of directly impacted folks, formerly incarcerated folks, and their family members. And these folks basically got together and said, hey, what's happening to formerly incarcerated folks when they get out is unfair, it's unjust, and we want to change that. And we want to make that illegal. And that's how we got the California Fair Chance Act. And I also want to note, though, that, you know, in this moment that we're in right now, I think that things that weren't politically possible a few years ago when this law was passed now are. And so I encourage you also to think about what are ways in which this law still continues to fail you, and what are ways in which this law isn't going to work for you, because that's something we're thinking about as well. How can we make our laws stronger so that we truly make employment after incarceration and finding a good living wage job after incarceration a reality for everyone?
The California Fair Chance Act was enacted in 2018, and it applies to private and public employers with 5 or more employees. And there are some exemptions that we'll discuss in the next slide. This law does 3 things, as I mentioned earlier. There's the off-limits information portion, the ban the box, and the fair chance process. For the off-limits information portion, this means that employers cannot consider certain off-limits information. For the ban the box portion of the law, it means employers will have to wait until they offer a conditional offer of employment before they can start asking about criminal history. And the problematic history has to be directly related to the job in question. So the question to ask here is there any relationship between the job and the conviction itself? As for navigating the fair chance process, the employer has a responsibility to tell the applicant if they'll be making any adverse actions against the applicant based on certain conviction history. And these adverse actions can be revoking a job offer, firing them, or suspending the employee. And so the notice that the employer has to provide in taking such adverse actions would have to identify the conviction that's problematic, and it would also have to include a copy of the background check report. And it would also have to give folks at least 5 days to respond. So if the decision is a final decision, then the employer would have to give the applicant a second notice that highlights the right of the applicant to file a complaint with the Department of Fair Employment and Housing, which is the California agency that enforces the Fair Chance Act. And we'll break down this law a little more, but it applies all throughout California. So it doesn't matter where you apply for the job, whether it's LA, Oakland, San Bernardino, or Palo Alto, the law applies. So some exemptions from the California Fair Chance Act means that there are places where the Fair Chance Act does not apply. And this would be places such as the police department or district attorney's office, farm labor contractors, and positions where a criminal background check is required by law to conduct. Employers have to conduct criminal background checks by law, such as local and state agencies. And others include where folks will be working with vulnerable communities, such as the elderly and children, such as in schools. So some of the off-limits information that we want to talk about today that the Fair Chance Act prohibits employers from looking at and from asking employers about such information are highlighted in this slide. So even if employers accidentally get such information, they still can't use it to make any employment decisions. So under this law, there are 5 categories of information that employers cannot use. The first is arrests that did not result in convictions. So if you were arrested or and they got the wrong person, or if they got the right person but they didn't have enough evidence to convict you, then employers cannot use this information during the employment process. The only exception is if the case is currently open. So if you are currently going through the criminal system, then they can use that information and that arrest in the employment process. The second item of off-limits information that employers cannot use is pre-trial or post-trial diversion program information, such as a substance abuse program. So if you entered this sort of program and didn't receive a conviction, then it can't be used by an employer. The third category is likely to be the most common one, which is judicially dismissed convictions or a certificate of rehabilitation. Clients usually call judicial dismissals and other sorts of dismissals clean slate remedies or expungements. And expungements doesn't technically exist in California law, but it means your conviction has been dismissed, perhaps through a clean slate program. So if your conviction has been dismissed, then your employer cannot use this conviction in making a decision about your employment. And then the last 2 types of off-limits information are judicially sealed convictions, pardons, and juvenile court involvement. So if you went to court and got a conviction judicially sealed, or if anything happened in juvenile court, then employers cannot use this information at all in the employment process.
Okay, so now we're going to jump to the ban the box portion of the law. And when we say ban the box, you might be asking yourself, what box are we talking about? And so it's the boxes that are showed in the images below. Have you been ever been convicted of a criminal offense? Check this box, yes. Have you ever been convicted of a felony? Check this box, yes. Have you ever been convicted of a crime? Check this box, yes or no. Have you ever been arrested? Yes or no. And so these are the types of questions that for most employers now are unlawful. You're probably still seeing a lot of these on the applications that you're applying to, but for most employers, these are now illegal. And the reason for that is that the Fair Chance Act says that most employers are not allowed to ask about conviction history on a job application or interview or run a background check before they offer the applicant a job. So that timing piece of it is really important. We're gonna have a pop quiz here, and we didn't warn you about it because it's a pop quiz, but I'm gonna ask you in the chat to put in A, B, C, or D after I count to 3. So I'm gonna read the question, read the answers, and then give you a little bit of time to think about it. When can a potential employer ask about a criminal record? Is it A, before giving someone an application, B, on the application, C, during the interview, or D, after offering someone a job? So I'm gonna count 1, 2, 3, enter your answers. Great, I'm seeing a lot of Ds. And that's exactly right. So, right, that timing, right, after giving someone a job offer. And that's where we're going to jump to now. So after the job offer, and a lot of times you'll see language like conditional job offer. That's what they'll call it. That's what the law calls it. Sometimes employers will say, congratulations, we're hiring you contingent on a background check or subject to a background check. That's the type of language that we often see on like offer letters. And after that, after they do that, then employers can ask about criminal history and can run a background check. They can't ask about what Molly told you about, right? All those different categories of that information still, they can't ask about your dismissed convictions, et cetera, et cetera. But they can ask about your other criminal history. They do need written permission from you to do a background check. And sometimes they'll do that as part of the offer process. Sometimes they'll do that up front at the application process. Sometimes on the application, you'll see a different box that says, check here if you give us permission to run a background check after we've given you a conditional job offer. And then check here if you want a copy of that. So just a heads up that sometimes employers will put the written permission at the front end. So we have our process at the bottom here. We start with the job application where the employer can ask about criminal history. The interview can ask. Then we have our golden ticket job offer. And then you could go straight to work. Most employers aren't actually required to run a background check, but if they do, this is the time to do it. And then ideally we go to work. So that's the best case scenario. But now we're going to talk about if that scenario doesn't happen, right? And so this is where we start to talk about the fair chance process. And that's something that we've started calling it. It's not something that the law uses, but I think it's an easy way to think about it. So an employer can say, after looking at your background check, they say, I don't think I can hire you anymore. They can do that, but they have to follow a few steps to be able to do that. So the first thing they have to do is they have to tell you, and that has to be in writing, right? So I have to tell you, we reviewed your background check and we're considering revoking your job offer, taking back your job offer, not hiring you because of it. And in that letter, they have to tell you what specifically about your background check is the issue. So which conviction? Is it my 2011 theft conviction? Is it my 2019 burglary conviction? Which conviction is it that you have a problem with, excuse me. They also have to provide you a copy of the background check and give you a date by which you can respond. And that has to be in California at least 5 business days, which is a pretty short amount of time, but it's you know, also the most we could get sort of through the legislative process. And as part of this process, the employer has to do what's called an individualized inquiry, which I like to say is sort of like they have to recognize that you're more than just your criminal record, right? They can't just say, I'm not going to hire anyone with theft convictions, period, for any position whatsoever. They have to look at how long ago was that conviction? What were the circumstances leading up to the conviction? What have you done since the conviction? And what's the job? Does the job actually have anything to do with your conviction? And Katie will give a great example of that later on. That's my favorite example of it. And then, so you have the opportunity to respond. And Katie will also walk through what your response can look like during the second part of the presentation. But once you respond, which we really encourage you all to do and we can help you do, then the employer has to do that all over again. They have to do the individualized inquiry again with the new information that you submitted. And they have to say, okay, now that I have this additional information, does this still mean that this person should not be able to do this job? And the whole process is designed to make employers say, oh, wait, no, this doesn't make any sense that I'm preventing this person from working because of this conviction. But if that doesn't happen, if the employer still says, even with this new information, I'm not going to hire you, then they have to give you that final notice that Molly talked about, where they have to tell you that you have a right, if you think that your rights were violated, to file with the Department of Fair Employment and Housing. And so we have our process at the bottom again, that job offer. And here the employer decided to do a background check. We have our first notice in writing before the revocation. And then we have the opportunity for you to provide a response. And then ideally we go to our green work box down there, but if not, then we go to a final written notice. So we have another pop quiz here. So can a covered employer, because remember there are some exceptions, ask me about past arrests? So I'm going to ask you to put in yes, no, or something else if you're not sure about that in the box on 1, 2, 3. Okay, I've seen a good amount of no's, some yeses. It's almost, I'd say maybe 75-25 no, yes. Okay, so it was a trick question. So no, but remember that exception that Molly talked to us about, unless the case is currently open. So if you're currently going through the criminal system, if your case is not yet resolved, you haven't pled, you haven't gone to trial, then the employer can consider that information. But if not, if the case is closed, then they can't consider it. What about dismissed convictions? Can a covered employer ask me about dismissed convictions? I've seen lots of no's. Yes, that's exactly right. And that's a really good reason to go through these clean slate programs or expungement programs, right? That if you get a conviction expunged, then the employer can't see it. And if they do happen to see it on accident, then they can't use it, right? So they might say, and that's the part, that's the reason why identifying the conviction is important, right? If they tell me my 2019 robbery conviction is the reason I'm not hiring you, but then I can say, hey, that's expunged or dismissed, right? So you can't consider that information. So if that's the only reason you weren't going to hire me, then that's bogus and you have to hire me. Okay. Another question. Can an employer run a background check on me? So yes, no, or something else in the chat box. What do you all think? Only with permission. Great. After the offer. Yeah, exactly. So yes, but only after the job offer and exactly with your written permission. Okay. All right, and I'll pass it on to Katie here.
Okay, so navigating the fair chance process. And sorry about that music in the background, okay? So this is one of my favorite pieces that I really do love to educate about. This is going to be the common responses. And Stacy and Molly already kind of touched on some of these and why these are going to be some of your common responses that you have in your back pocket that you want to be ready and also able to point out to an employer. So one of the first ones is going to be errors in the background check. That is absolutely going to be one of the main tools you're going to be wielding around when you're speaking up for your job. You're looking for errors in the background check, and we're going to take a look at that. Mitigating circumstances. Again, you want to be ready and able to go ahead and speak up for yourself and be able to explain, what was going on at that time of your life. And also rehabilitation since offense. Super duper important. And we are going to look into what is considered rehabilitation since offense. And my last one that I really love as well, and Stacy touched on this one a little bit, is no relationship between a job and conviction in a passage of time. That is a directly related piece of the law that employers must follow. And we're going to get into that one too. Let me see, next slide. Okay. Background check. So remember, we're looking for errors in those reports. So one of the main things and one of the most important things you want to do is ask for a copy. In the state of California, it's the law that you can get a free copy when you, and this is at the time you authorize the background check. There's also another box that says, would you like a copy? And it says some other stuff, but in the state of California, absolutely you would like a copy. And one of the first things you want to be looking for is that background check incomplete? So when you get your background check, you want to be looking at dates. And for all my service providers on the line, absolutely. If you're in a position to help somebody, take a look at the background check because it's going to be raw data. It's going to be hard to figure out what to read. You want to help them look for dates. When was it initiated? Because again, like Stacy said, they can run a background check only after you receive the offer. So it's a little tricky, and you see this stuff all over the place out here. Like she said, when they say, can I check here for permission to run a background check after we make you an offer? So you want to look to see what date was that background check initiated. Was it initiated the same day you checked, yes? That means that was initiated before a conditional offer was made. So you want to be looking at the date it was initiated. And again, was it incomplete? In my case, I had a background report come back with a missing date. That's invalid. Next slide, please. Again, proven errors. And this is one of my favorite slides right here, because as you can see, the stuff is going to look all kind of ways. You know, again, it's going to be raw data, depending on the county you're in. You know, it's hard to read this stuff. You want to be looking for dismissals, you know, that employers are going to have access to. Sorry about that background noise. I'm at a car dealership, so I really apologize. If you can't hear me, somebody give me like a signal. Um, but yes, you want to be looking for a case dismissed. These things are popping up on a background check. And again, that's off limits information. Also, another one of my favorite errors is multiple convictions showing up in different times. So you're going to have that same robbery conviction, but it's going to be on there twice. You know, it's going to be on there in February when you got arrested, and then it's also going to be on there in December when the case was ultimately closed. So that looks like I was arrested for 2 robberies in the same year. So you want to be able to look for that stuff and be able to explain that stuff, you know, to whoever it is that you're dealing with at HR. Sorry if I took too long on that one. Okay, another one of my favorite slides. They are my favorite slides, really. Changes in evidence of rehabilitation. You know what, folks? There's no shame in our game, okay? There is really no limits to what we can consider when we are responding and speaking up and submitting proof of rehabilitation. And we're gonna go through these. Proof of enrollment or completion from high school, GED, associate's degree. Absolutely, that stuff matter. You went online and took an online GED class. Absolutely, you want to go ahead and get a copy of that stuff and put that in your package that you're going to be submitting to that employer. Letters of recommendation from those same previous teachers and professors. Absolutely, you want to go ahead and ask the teacher if they can write you a quick little letter saying whatever it is that they feel comfortable putting on paper for you. Proof of completion of a rehabilitation program. Absolutely. There's no shame in our game. You completed an anger management program. You want to go ahead and get a copy of that and get that submitted to an employer. That shows you've gone above and beyond. You've completed an NA or AA program. Absolutely. You want to go ahead and get that. And in my opinion, I don't care who you're getting it from. You could be getting a letter from the person working the door that's just been seeing you coming every day. So what? Anything matters, in my opinion. Letters from probation or parole officers attesting to you satisfying the terms. I know this can be a little intimidating. You might still be on active parole or probation. And a lot of times we have adversarial relationships with our officer, and you don't know if that's something that you can step to them and ask. Absolutely, you can. I did. In my PO, yes, it was a little cheesy what she wrote, but so what though? She wrote something. You know what I'm saying? And I do believe too that could also change the dynamics of a relationship with your PO and your parole agent. You coming to them, asking them to write you a letter to get a job. In reality, what they look like telling you no. You know, and that also lets them know that you really out here trying. And if you can please do this one little thing, I will really appreciate it. So absolutely do not be intimidated when it comes time to step to your P or your parole officer to ask for a letter. Again, letters from a recovery program or a counselor attesting that you up in there. You might not have completed the program, but again, you showing up every day, you participating in all the little exercises that they got going on. I don't care. All that stuff matters. We're trying to get our jobs here. And for service providers, again, if you are a counselor or a case manager or something like that, maybe, you know, you have more time on your hands or a little more access to reach out to, you know, some folks that you know your clients is involved with some type of training. Be that person that's willing to go the extra mile to help someone secure a letter. Proof of community service, education, or other self-improvement efforts. So we already talked about if you completed high school or you going to school to get a degree or something like that. We already talked about get something from the NA program, but proof of community service. You've been showing up every day at your kid's school, helping out with, I don't care what you've been helping out with, some bag lunches, helping make sure the kids get across the street, whatever it is you've been doing for community service. You want to get that submitted to that employer because that says a lot about you. That shows that you're willing to go above and beyond for anyone that's involved with you. That shows that you are active in your rehabilitative efforts and other self-improvement efforts. Even if you just took a small little computer class that will help you be a little bit better at your job, you want to go ahead and show that stuff to an employer. Letters from a psychologist or other mental health professionals. If you in active current therapy for whatever the issues could be, you know what I'm saying. You've been diagnosed with PTSD, or you just going through some therapy classes for some anxiety. Maybe people just came home. You want to ask your folks for a letter of support. It goes a long way. You'll be surprised. Those people are here to help. Letters of support from other people not mentioned above. In my personal opinion, I asked my cousin. She's a nurse, and her letter was sweet and simple. My cousin Katie has been missing for a while, but it's nice to have her home and have somebody that I can barbecue with. That goes a long way. Again, it's endless, the stuff that we can use to show what we're doing in the community. And my last personal one, your personal statement describing your rehabilitative efforts. This is going to be super duper important. And I know this can be a little intimidating too. You done got the bad news that your background been flagged. You possibly not getting that job. You was hoping for that job. You could be a little flustered. You don't know what to try to say. You know what? We got some fantastic examples coming up that we want to share with you all that can definitely help somebody get started on drafting your personal statement. This is going to be your opportunity to go ahead and speak to those mitigating circumstances. I was poor at the time, I was homeless, and I was just trying to get a little money, and that's what led me to commit that robbery. But since then, I've been doing X, Y, and Z to put my life back together. Okay, so absolutely your personal statement. Next slide, please. Proof of changes. This is just some real life examples of what it looks like and what kind of stuff you want to be submitting. My favorite one, I know you probably can't see it. This one is from a residential drug abuse program. I know we don't use that language no more, drug abuse. That terminology is definitely outdated. But the point is, you want to go ahead and get a certificate from whatever type of program that you're either currently in or you participated from. We got an anger management certificate up there. Absolutely submit that stuff. We got a Solano Community College certificate. That is absolutely important. You see this one page right there, that looks like just a sheet where maybe you logging in your community service hours. If that's all you have, then that's what you're going to be submitting. That is nothing wrong. Again, there's no shame in our game, and there's no limit to what we can submit to prove what we have been doing in the community. And yes, here's the next slide. So right here, again, this is some real-time examples from real clients. It may be hard for you to come up with the beginning of. This is a real example that you can use. And Stacy and Molly is going to read one or two of these out loud because like this is important for us to go ahead and give this example. Stacy, Molly.
I'll start with the top one. From the time I was 18 years old until I turned 25, I struggled with drug addiction. I was convicted several times for drug-related offenses. I regret this period of my life, and I take full responsibility for my actions. After my most recent conviction in 2014, I entered a residential drug treatment program for 18 months. I successfully completed the program, and I am proud to say that I have not used drugs for 5 years. I also moved forward in other areas of my life. I obtained my high school diploma and now volunteer with an organization that mentors young people with risk factors for substance abuse.
And the next letter is, in 2012, I was convicted of grand theft and sentenced to 3 years in prison. During my incarceration, I realized how my actions hurt other people and learned how to overcome the urge for instant gratification. I dedicated my time to reflection, self-improvement, and ultimately discovered my passion for learning and technology. After taking all of the available classes on computers and engineering, I am grateful to have received extensive training in this field. Also, I worked as a mechanic for 18 months, and I was proud of being promoted after 1 year of hard work. I'm excited by this job and the opportunity to work for you.
Thank you so much, ladies. I really do love these statements because first off, they address what you did, they take personal responsibility, and it just goes directly into the things that I've done to change my life. And I love the bottom one. I'm excited about this job and the opportunity to work for you. That's speaking directly to that employer, letting them know that you're serious. Common violations. This really is my favorite slide. Out of all the slides, I'm serious because like Stacy said, yes, this stuff is all over the place and you are still seeing folks asking about convictions on the job applications. Okay, so yes, the law has been on the books for a couple of years now, and there is some level of understanding amongst people, but everybody's level is all over the place. And so you are still seeing that box on applications. Conducting a background check before the conditional offer of employment. Again, like I said, it's a little tricky out there. Amazon and all kind of folks doing this stuff. It's all over the place out here. We got to get on top of this. They doing everything on the same day. So that's when you asking for your background check. You want to be looking at the date that background check was initiated. It is super important. Stacy touched on this one, implying and stating that no individuals with convictions will be hired at all. No felonies. You see this stuff all over the place on Craigslist, okay? That stuff is illegal. If it's not one of those 2 to 3 specific exemptions Molly talked about, it's illegal, okay? So you are still seeing it. Like I said, Craigslist is my favorite place where I see it all over the place, that no felony statement at the bottom of the announcement. Considering off limits information. Absolutely. You know, at the end of the day, I like to give folks the benefit of the doubt. People are human. Folks don't understand what's going on. If you just dealing with plain old, Becky that work up in HR, she don't know that this information is off limits. All she knows is that she got a background check back and all kind of stuff was flagged. So she just submitted all this off limits information and now your job is on the line. You know what I'm saying? I don't want to let Becky off the hook here. I'm just being realistic. Folks are considering off limits information, and 9 times out of 10, they need some training too. And we're out here working hard to get them trained too. Improper process for notifying applicants, or as in my case, no process at all. Once the employers or the folks in HR get the background check, you automatically deny. They just stop responding to you. Maybe on their end, ain't no need because you're not gonna get a job. That's illegal. And that's not the proper process for notifying applicants, okay? And they must follow the proper process, which is providing you a copy of the background check. And that's the next one. They are failing to provide that copy of the background check. So yes, you did get a copy of the background check when you checked that box at the beginning of the process. That was your copy that you got free from whatever third party or whoever ran that background check. That's the one you preparing your responses off of. Now that the employer has found something that they plan to use to deny you, they also need to submit to give you a copy of the background check identifying the convictions that was related to the job. Like Stacy said earlier, that background check that they give you, it can't just be like, I'm gonna deny Katie because of the 2011 car theft. No, that's not gonna work. Now, a good example is if I'm applying for a bank job, I'm applying to be a bank teller. Now, I know I was robbing banks though for the last 10 years. That is not gonna work. That's the type of stuff that you can be denied. That's a directly related conviction to the bank teller position, okay? Those are the type of convictions the employer must identify. Again, not the car theft that happened in 2011, that one don't qualify. But the bank robbery in 2012, that one does qualify because I was applying for a bank teller job or whatever else they do at the banks. And then, I missed my last one. Go back one more slide for me. Okay, this is my last one. Failing to provide 5 business days. And if you're in San Francisco, it could be a little bit more. But failing to provide 5 business days for the applicant to review and respond. So a lot of times what they're doing is sending out the pre-adverse action notice and the final notice all in the same day. That's not the proper process. That's not 5 business days. And that's not even an opportunity to review and respond. You sent everything out at the same time. So you are seeing a lot of that. Okay, and if violations happen, Okay, folks, this is super duper important. If you find yourself, and for my service providers as well, you got a client that you working with and they coming to you frustrated, they feel like their job being denied or they haven't heard from these people, document what's happening. Journal notes. Right now, most things are going to definitely be text messages and emails. You want to be saving all that stuff. You want to be screenshotting the applications. You want to save all that stuff that whoever you dealing with, whether it's a third party agency, because you know how some of the temp agencies are hiring for other folks. So you might be dealing with John over there at Labor Ready, or again, you dealing with Betty that work directly for the company. You want to be saving any type of correspondence with these people. That's one of your best, your evidence. Informally resolve. I love this one because you really will be surprised if you just step up and say something informally. You will be surprised how often this stuff can get resolved. Now, it does take a little understanding and maybe a little bit of confidence for you to draft a little letter and say, hey, look, I do believe that there's a law on the books and that you also have to kind of like consider me. And also, did you know about like the bonding program and all these different incentives? Again, for the service providers that's here with us today, if you can help folks, because people might not even know about all that stuff. And again, you upset, you've been denied the job. So again, trying to inform and step up and say something informally, that's a direct avenue. Okay. The next one, prepare, prepare, prepare. Again, knowing your rights and knowing your records. You want to be out here taking advantage of these clean slate programs because that's really the first step to knowing your rights and knowing your records. You want to already know what you got on there, how old this stuff is. It took me a while to figure out my personal background. I had a little help. Someone had to help me figure out again, why is this conviction on here? So take advantage of these clean slate programs. The process is getting easier. They got some bills and laws just passed. Some of this stuff is being automated now. So that's one of your first things you want to do. And gathering support letters. That was one of the hardest parts for me going through the clean slate program, is gathering support letters from who, you know, you want it to be of quality. You want to be doing that stuff ahead of time. Prepare, prepare, prepare. Take legal action. Consulting with an attorney. This is built into the Banner Box law. It is your right to file with certain government agencies. We touched on it earlier a little bit, the California Department of Fair Housing and Employment. When an employer is go ahead making that final decision to deny you, they have to also include your right to file with that agency. We need folks to go ahead and exercise their right to file with these agencies. We working hard to get this stuff a part of these laws, and it's not going to work if you don't exercise your rights. And another main thing, there are deadlines to file these complaints. Okay, there are deadlines even if they don't have the right to file. Yes, the deadlines can be as short as 90 days and they can be up to 3 years. Okay, so again, folks is a little upset. You don't got time right now to be trying to fill out this paperwork. I'm trying to get another job. Again, for the service providers, you know what? Be that person that's willing to go above and beyond as a case manager. Help folks get that stuff figured out. Help connect folks with legal aid at work. Help them get online with somebody at a root and rebound or something like that. That will help people with some of this stuff. And the last one, turn to your community. I'm a proud member of All of Us or None, okay, folks, in the IE Fair Chance Coalition. You guys want to be turning to your community. If you find yourself in a situation, they playing with your job, you want to turn to your community. Case managers as well, service providers. No one said you had all the answers, but you can also turn to your community to ask for help. Hey, I got a client was just denied the electrician job after they went through the school. You can get hooked up with somebody. Maybe we can use you somewhere to organize around what's to come next in the Banner Box landscape. So definitely turning to your community is going to be just as important with filing with these government agencies. In illegal discrimination, there are tons of other areas of illegal discrimination that, in my opinion, I do believe are intersectional. Not all of them, but definitely more of them than not is going to be intersectional with folks that's either poor, black, brown, and folks with a criminal record. Okay, race and ethnicity, again, that's our poor, black, and brown folks. Gender discrimination, that stuff is out of control and it's all over the place. National origin, we already know what's going on with that kind of stuff. Religion discrimination, absolutely, that's a real thing. Pregnancy discrimination, age discrimination. I have worked amongst folks who was being discriminated against their age, okay? Disability, this is real stuff. Yes, we already know that includes mental and physical, but it can also include past drug addiction. And Stacey will speak a little bit more about it later on, but that stuff is real and it's all over the place. Sexual orientation, absolutely, that stuff is happening, folks. Military gender identity discrimination, that stuff is rampant, it's on the rise, and it's all over the place. We got to get on top of it. Military and veteran status, people are definitely discriminating against folks that have put their life on the line to represent the country. And status as a domestic violence survivor, believe it or not, those folks are vulnerable and they are being discriminated against as well. And 9 times out of 10, you're going to be finding that intersection with folks with a criminal record being denied their rights and being discriminated in their employment because of their status as a domestic violence survivor. That stuff is all over the place. And I think with that, I'm going to pass it back to Stacey. She's going to go ahead and give us a little bit more stuff about the legal information on some of this discrimination I just talked about.
Yeah, thanks, Katie, for contextualizing that for us. And, you know, we really want to recognize that this law, the Fair Chance Act, is built into our general discrimination law in California, the Fair Employment and Housing Act, which isn't an accident, right? There are certain communities that are disproportionately affected by our carceral or criminal system. And so we want to, we always sort of think of these issues through that racial equity lens and other types of equity lens. And there are 2 types of discrimination that the law recognizes. There are many more, but there are 2 types that the law recognizes. And one is sort of what we think of when 2 people are treated differently, right? So for instance, if someone's treated if an employer treats your criminal history more harshly than another job applicant who has a very similar criminal history because of your race, color, religion, sex, sexual orientation, national origin, disability, all the things that Katie talked about, right? So if, for instance, my theft conviction from 2 years ago is treated very differently from a white man's theft conviction from 2 years ago, maybe that's because of our race or national origin, right? Or for instance, if my theft conviction that's related to my past drug addiction is treated differently from a theft conviction that doesn't have a past drug addiction history, then maybe you have an illegal discrimination claim. The other one is a little bit more abstract, and that's when there's a neutral policy or practice that disproportionately screens out a group based on a protected characteristic. And the law says that that policy has to be something that's not job related or not consistent with business necessity. So those are a lot of legal words, but I want to give you a really concrete example and one that we've talked about before. A no felonies policy, or a policy that says, I'm not going to hire anyone with any criminal convictions in the last 7 years, right? On its face, that's neutral. It doesn't say I'm going to hire more white folks than I'm going to hire black folks. But in effect, what that's going to do is it's going to screen out more black folks than it will white folks. And because it's such a broad policy that's not tied at all to the job that you're doing or to who you are as a person, what you've done since the conviction, right? Then it's probably something that's not going to be job related and not consistent with business necessity. And then we briefly want to highlight other rights too and let you know that Legal Aid at Work works on all of these different things, basically anything that with a connection to employment we work on. So disability rights, like Katie mentioned, you know, includes things like deafness and blindness, mobility impairments, what we usually think about when we think about disability, but it also includes things like hidden disabilities like PTSD, mental illnesses, depression, anxiety, cancer, diabetes, things we can't see. And the rights under these laws include not only the right to be free from discrimination because of your disability, but also something called a reasonable accommodation, where the employer makes some sort of change to your work in order to enable you to either do the essential duties of the job or to protect your health or for some other reason like that. So for instance, and then another reasonable accommodation can also be a leave, like if you have to take time off from work, and then the state disability insurance program provides benefits, monetary benefits for that time that you're not working, so you have another source of income. And a concrete example of this is a past drug addiction, right? So I've had clients, for instance, who have had a heroin addiction and are receiving methadone treatment right now, aren't engaging in any illegal drug use, and the employer has a drug test as part of their application process. And so we've asked as a reasonable accommodation that they not have to pass that drug test, because it's crucial to their health that they continue doing the methadone treatment, and that's going to mean they're going to fail the drug test. Rights of domestic violence and sexual assault survivors at work, who we also know are disproportionately criminalized. So those can include rights to not be discriminated against because of that, and the right to take time off to seek medical or legal help or to go to court, and also safety-related accommodations. There's also immigrant workers' rights. So undocumented and immigrant workers have the right to be free from discrimination because of national origin. And all the protections that we've talked about today up till now apply to undocumented workers. The only exception to that is the unemployment insurance, which we'll talk about at the very end. And then work and family related rights. So pregnant women, new parents, and caregivers may have the right to take time off work, to paid leave, and to workplace accommodations for their own health, for a family member's health condition, or to bond with the new child in the family. And then finally, unemployment insurance, which is a benefit for workers who've become unemployed through no fault of their own. I think people usually think about it as just being laid off, which is right, but it can also include workers who quit with good cause. Particularly right now, if there's some sort of like health implication of you going back to work, for instance, or of you continuing to work, you may still be eligible for unemployment insurance.
I'm going to talk a little bit about some of the resources about the Fair Chance Law. And so you can always reach us here at Legal Aid at Work. We have attorneys in different programs, clinics, limited rep actions, help to fill out paperwork, helplines, and consultations. And the staff here are really happy to help with issues pertaining to the employment process itself, but we don't do any expungements or dismissals. For that, you'd go to organizations like Katie mentioned, Root and Rebound, and we're happy to provide a list for that later on. And there are also government agencies that you can reach out to, such as the California Department of Fair Employment and Housing. And that's built into the law, again, because you can file the complaint with them. As part of the final denial, this agency has to be in the notice so that you know you can file a complaint with them. We encourage you to be in touch with them, and if you get a final denial notice from an employer. You can also reach out to the EEOC, the Equal Employment Opportunity Commission. They do federal work, and so you'd want to make sure if it's appropriate to file a discrimination claim with those folks as well on the federal level. And then there's the California Labor Commission office where you can look at their website and check around for resources. So lastly, there's the Ban the Box toolkit for employers. There's information there to incentivize fair chance employers through tax credits and bonding programs, and information also about what the law requires. And at the end of the presentation, the members of the Inland Empire and Fair Chance Task Force will provide a list of resources to go over and help regarding the Fair Chance Act.
And I wanted to mention as well that we're seeking help with a new resource that we're currently in the process of developing, which is a toolkit for job seekers with criminal records. It's going to include, basic know your rights information, like what we just shared with you, but also we're trying to include practical information about what's worked when people have applied to jobs. So if you yourself have applied to a job and have had, for instance, a good experience answering an illegal question that's asked, or explaining a gap in your employment history, for instance, if you could share that with us, or if you'd want to look at a draft of what we already have based on our experiences, we would really appreciate that. And then the other significant part of the toolkit is sample letters for everything we talked about, for that big list, right, that Katie went through with you. And here, for instance, is a sample letter that I wanted to share with you that's very much in draft form, but you could also help us by providing comments about this letter and how useful how useful things like this you've written before have been with employers, or how not. And it describes sort of the relationship to the applicant, and then what
describe sort of good qualities that that person has had experience with that we think would be helpful to employers and that has been helpful in our experience. But, you know, we sort of want to draw on collective wisdom in putting this toolkit together. And that's it. We have our contact information up here, a helpline number where workers can call to be connected with us, and then the best number to reach us right now during COVID times.
Great, thank you so much. And we're going to share this whole slideshow with the folks who are on the call and the folks who are SVP'd so that you can have all the contact info. You don't have to be furiously writing. We're going to have space for questions in just 1 minute, but I do want first now to turn the mic over to Brandon Butler, who's a lawyer with the California Department of Fair Employment and Housing, who is the civil rights agency responsible for enforcing this law. And he is with us today just to kind of speak for the state and the importance of this issue.
Well, thank you, Jennifer, and thank you everyone in Inland Empire for this opportunity today. And it's great to hear from Legal Aid at Work. Legal Aid at Work is such a great partner. So really thank you to everyone. And yes, I'm Brandon Butler. I'm the Assistant Deputy Director of Education and Outreach at DFEH and a civil rights attorney as well. And, you know, I mean, I really want to say that as we look at the past events of the last couple of weeks and regarding the execution of George Floyd, you know, we really are able to bring home the issue of, you know, what is structural racism? You know, what is it and what are the symptoms of it? And I think when we look